Is that everyone?
I believe so, Your Honor.
Okay, let's proceed.
Thank you, Your Honor. As I said, we are the movants in this hearing, and if you enable me to screen share, I'll show you a.
I just did.
Okay, hang on 1 second here. Perfect. Thank you, Your Honor. Okay, Your Honor, the reason why we filed this motion today is that the discovery that is sought by the plaintiffs is really outside the scope of discovery and is really intended to harass, embarrass, and annoy my client by flagging this litigation and its many overreaching claims in front of my client's new employer, who has absolutely nothing to do with this case. Just by way of quick background, the present litigation is rooted in a December 2017 transaction in which the plaintiff, or one of the plaintiffs, Compass Data Centers, acquired certain companies from my client, his former business partner, Jonathan Trout, and their holding company, Bitbox Holdings, Inc. Now, the plaintiff, Compass, constructs data centers, and the other plaintiff, EdgePoint Systems, which was acquired by from my client, constructs what's called edge data centers, which are just basically, in a nutshell, miniature data centers. And the other company that was acquired, Bitbox, is a platform that monitors edge data centers. And my client, Mr. Fotu, his role at EdgePoint and Compass was to lead the design and marketing efforts around bringing edge data centers to market. Now, the plaintiffs filed their original action on August 26, 2020, against 5 parties, which was Jonathan Trout, his wife Vanessa, my client, Bitbox Holdings, and CheckHub Inc. And then on January 14th, 2021, the plaintiffs filed a non-suit with prejudice as to all of the defendants except for Mr. Fotu, leaving him the only remaining defendant in the case. And then on March 8th, about 2 months later, the current plaintiffs filed their second amended original petition against Mr. Fotu, adding a whole bunch of new claims in addition to the original ones, which now total 13 claims. The slide here just shows kind of a summary of the 13 claims, but really what they do, most of them relate to the underlying 2017 transaction and the allegation that my client either breached his contract with them on the transaction or committed fraud and things of that nature. And then there are also some claims regarding his employment with the plaintiffs from 2017 to 2020. Now, currently, Mr. Fotu is employed by a company called 2K Games, which is a subsidiary of Take-Two Interactive, which is the party that the plaintiffs are trying to, or the non-party that the plaintiffs are trying to subpoena. And 2K publishes video games, which of course is a very different type of industry than what Mr. Fotu was at with Compass and with EdgePoint. Importantly, there's no claim in plaintiff's petition that Mr. Fotu's current employment with non-party 2K or Take-Two is wrongful in any way. In fact, Take-Two is nowhere mentioned in plaintiff's 28 petition. So the subpoena, the slide shows the 4 categories of documents that plaintiffs are trying to seek from non-party Take-Two. And they're really just overbroad categories of documents. I mean, at best, the subpoena is a mere fishing expedition that's not reasonably calculated to the discovery of admissible evidence, because Mr. Fotu, his employment has nothing to do with the claims that the plaintiffs have alleged in this in their current petition. Now, in response to our motion for protection, in a nutshell, Compass claims that there are 2 reasons why they have subpoenaed non-party Take-Two. The first one is, as you can see, to the extent Fotu touted any false accomplishments about his time with the plaintiffs to gain new employment, whatever employment that may be, or his reasons for leaving, those statements are within the scope of permissible discovery. That's in paragraph 11 of their response. And then their second category is, or reason is, Fotu's statements about the litigation are obviously relevant no matter who receives those statements. Now, Judge, neither of these propositions describes how Take-Two has evidence directly related to Compass's claims. I mean, in the first category, really, I mean, that's a big, so what? What does any after the fact statements about that Fotu may have made, which probably were none, to his new employer prove regarding the underlying 2017 transaction or his employment with plaintiffs? Similarly, with the second category, I mean, that's really overbroad. I mean, any statement that he may have made to anybody, his neighbor, his wife, well, not his wife maybe, but whoever, about the litigation, I mean, there's no basis for that. It's just assuming he said something. Again, it's a fishing expedition. And moreover, when the lawsuit was filed, Mr. Fotu had already started working for Take-Two. So during his interviews, he wouldn't have talked about the litigation. And the only time that he's briefly had a discussion with Take-Two is when the plaintiffs promulgated a litigation hold letter and sent a copy of the petition to his employer, which of course they then sought to make sure that they complied with. So again, this broad document request is really just a thinly veiled guise or disguise for the harassment, embarrassment, and annoyance that Compass is intending to cause by flagging.
I guess my main question is,
Sure.
What relationship is there between this underlying lawsuit and his new employer? It's not a situation, as I understand it, where there's an allegation that we see this a lot, where executives leave one company and then take information to another company and they're suing for breach of the covenant not to compete or non-solicitation, or they want the return of confidential information. That doesn't sound like what's going on here, though. Is that correct?
That is absolutely correct. And that's the reason why we are filing this motion for protection. There's no claim whatsoever like that. This is not that type of an employment law case.
All right, Mr. Lemoyne.
Yes, if I can, I'm assuming for modest, if I can share my screen now, so.
Lemoyne, I can't hear you. I'm so sorry.
Is that any better?
A little better.
Let me do something differently. I realize my speaker wasn't working well.
I apologize. I still can't hear you. I mean, I can hear you. I just can't understand what you're saying.
Is that any better, Judge?
It's a little better, yeah.
I tested the speaker before.
Go ahead. Mr. Lemoyne, you can go ahead. Oh, go ahead. Okay.
Sorry. So obviously we disagree a little bit with Mr. Hamada in terms of how he classifies the case. One of the things the jury will decide is whether or not Mr. Fotu lied to us in 2017. And while acknowledging what the court said about what kind of cases we typically see, this one's pretty rare in that not only did Mr. Fotu lie to us on the front end of his relationship with the plaintiff, but he lied on the back end. Specifically, he lied to us about having a mental health issue, so that he's obviously a protected class person. He gets to collect salary for a while. We go to him in February and say, "How are you doing?" And then his response to that is, "Oh, I'm leaving. I'm going somewhere else." And so what we don't know is what he told his new employer, Take-Two, with regard to that. Because either you have a mental health and drinking and stress issue and you can't do your job, or you don't. And if he is at the same point in time interviewing with Take-Two, at the same point in time he's telling us he can't work because he's got problems, that just goes to, if one, it goes to one of our specific claims, which is fiduciary breach. Two, it goes to his credibility, which is going to be, I think, something that's critical for the jury to examine in this case. And this is all laid out in the petition, and this was attached to our response. I mean, literally, our client is asking about how he's doing on February 6th. After he's taken some time off, continued to collect his salary because we can't obviously you're not supposed to fire somebody when they have a disability like that. And the next thing we know, he runs out the door, and then we have a short-term relationship with him, and then he's working at Take-Two. So one of the arguments that Mr. Hamada raised, which is a good one, is why not ask Mr. Fatu for the documents? Well, the reason is that before we subpoenaed Take-Two, we asked Mr. Fatu for communications that he would have had with a third party about the plaintiffs. We're not asking, unlike some cases, we're not trying to dig into his work file, how he's been doing at this company, anything like that. All we want to know is what he said to them about us and about his employment with us, and more importantly, kind of the timing of those discussions. I think the first thing that's easy to dispose of is whether or not there's a burden, because there's not. Mr. Fatu is not making an argument that this would be burdensome to him. It's not, and he wouldn't have standing for it even if he wanted to. So Mr. Hamada classifies our request as very broad. Well, if there were a bunch of requests or a bunch of information that this would dredge up, you would have some kind of burdensome evidence, some kind of burdensome argument. That's not being made. Mr. Fatu either did have communications and sent them that referenced the plaintiffs, or he didn't. And that's very simple and it's very straightforward. And they either exist or they don't. And so we don't think that there's anything improper about that, especially given the way that he left our business. This is not an example of him just getting up and saying, I'm done with you, I hate you, I'm going somewhere else. He actively misled us and then ended up in another place working. Mr. Hamada relies on a sexual harassment case out of the Northern District. And what that case talks about, and I agree with it entirely, we're not asking to dig into Mr. Fatu's file. We're not trying to figure out what kind of employee he is at Take-Two. What we want to know is what he said to them about us and what he said to them about his employment relationship and why he was leaving. And given the claim that we have for breach of fiduciary duty and disgorgement of salary, I don't know how that's not relevant to this case. And then the last thing I will point out to the board is we tried to work this out. And Mr. Fatu, in his original protective order, provided an unsigned declaration on March 26th. My guess is that Mr. Hamada intended to have it signed, and it wasn't. It was just oversight. When we saw that, we went back to Mr. Hamada, Mr. Mills that I didn't, and said, look, having signed the declaration that says that this is the only thing he's got, and then get Take-Two to confirm that he's not playing any games with us, and then produce whatever those communications are, and we're done. And we would be good with where we're at. But that's not what happened. It wasn't until the reply that I saw the declaration signed. And even then, we still have a situation where we're dealing with an individual that I know Mr. Hamada says he's innocent, and I know I say he's lying, but the one arbiter, the one group that doesn't have any skin in the game about what he did or didn't send to them and say to them is Take-Two. And so for those reasons, we think the court should deny the protective order and allow the discovery to occur.
Response, Your Honor?
Yes.
Yeah, briefly. So Mr. Fatu did sign a pretty lengthy declaration in support of his motion, and it was attached. What you saw was an unsigned one because we were at that point just attempting to confer with the opposing side. And additionally, there was a further communication that I had with opposing counsel where I said, upon further reflection of the rule, once you decide to, why don't you wait until requesting documents from my client relative to Take-Two, which they didn't do. It was an overbroad request for any communications with any third party, which, I mean, I just didn't even imagine they were talking about Take-Two, his current employer. And maybe take Mr. Sharif's or Mr. Fatu's deposition, and then determine if you need to even do discovery from Take-Two. Because again, Mr. Fatu in his declaration states, the only document I provided to to take two concerning, sorry, I'll put this on the screen real quick. The only document I provided take two concerning prior employment with EdgePoint or Bitbox is my resume, which he attaches. And he points out that the only communications with his employer regarding the above were his interview, which in paragraph 8, he says that just had to do with, since his job has no correlation with edge data centers, he didn't talk about in any detail responsibilities or capabilities related to the plaintiffs.
Mr. Hamada, can you show me the 4 categories of documents again?
Yes, absolutely. Hold on one second here. Here you go. Can you see it, Your Honor?
So Mr. Lemoyne, let me make sure I kind of understand what your argument about why you feel like these might be discoverable. Documents and communication with Fateau regarding his prior business and or employment experience. So your argument that would be something that would be discoverable because it would go to the issue of whether or not he made false representations to your client when he was employed there, and see if these, I guess, the representations lined up. Is that your kind of argument?
Yeah, yes, that would go to the 2017 representations about his business acumen.
Okay, response to that, Mr. Mata?
Well, Your Honor, again, in his declaration, he states that there were no discussions regarding why he left. It was just about his responsibilities and his work experience, not just with plaintiffs, but also with Google and other places. I mean, you know, that's what you would expect in an interview, not discussions regarding, you know, why he left his prior employment, at least, especially negative ones. And that's what the case that I cited really goes to. It's, you know, those types of after the fact discussions really, I don't even know how they have a bearing on the issues of the 2017 transaction and the one allegation that, which is not true, that he was somehow in breach of his fiduciary duty by not working hard enough or something at EdgePoint.
All right, I'm going to allow, it's a little bit tenuous, but I'm going to allow discovery as to what he represented in his actual job application, and if he submitted a resume, the resume or CV, but nothing beyond that. The second one is documents and communication regarding representations he made about Bitbox. Why is that relevant, Mr. Lemoyne, in this case?
Well, it would go to what work he claimed to have done for us. Part of our claim is that he didn't do the work that we hired him to do. So he rolls into take two and says, you should hire me because I created this edge data center while working for Bitbox, when he didn't, which is why he's getting sued. That was, I think, that is credibility.
Yeah, I mean, I just don't see how that's discoverable at this stage, Your Honor. It's very, the relationship between that, what they're seeking and the claims in this case, again, really about the transaction, the 2017 transaction. It's so tenuous, Judge. And again, I think that Rule 192 provides for you to be a gatekeeper as to, you know, deciding these issues.
It does seem pretty tenuous. Is that the same thing for EdgePoint?
Yes, Your Honor. But if somebody gets sued for working for a company, when they go to a third party and they, after the fact, and they tell the third party, I got sued, or not that I got sued, but I was a great employee there. After they've been sued, I don't think the court would have any hesitation to allow us to conduct discovery on that. The only difference between my hypothetical right now is we hadn't figured it out and hadn't sued Mr. Fitzgerald. But if he goes to his new employer and says, I was great, I did all these things for Bitbox and EdgePoint, when our position is he never did, I think that goes to his credibility, that he's willing to lie to us front end and back end and lie to new employees. And I don't know what he said. I mean, normally what I would expect is there are no documents. And then just say, we'd say, okay, there's no documents. But here, Mr. Amata is fighting this like there are documents that mention my client during this interview process.
I disagree, Your Honor. The reason we're fighting it again is because we think it's so overreaching. Its real intent is to harass my client in front of his new employer and to get in between him and his new employer, not to really litigate straight up the litigations in this, the matters in this case.
I'm looking at 2, 3, and 4. I do think they're all overly broad. I can't really see how they're going to lead to, if there's a way to limit 2 and 3, I'm trying to think of how to do that. Maybe limit it to any representations that Fotu made about the work he did for Bitbox and the work he did for EdgePoint. Maybe is that?
That would be fine, Your Honor.
Yeah.
Okay. Again, our position is, why not ask Mr. Fotu first, which I argue they haven't, and see if that's, and he's already stated they can even cross-examine him on his declaration.
Yeah, but you are able you are able to conduct discovery to determine whether or not a party's being truthful. So I'm going to limit it to documents. I don't know what communications are, maybe written communications with Fotu about regarding representation he made about the work he did for Bitbox and the same thing for EdgePoint. All right, anything else, guys?
Not for me, Your Honor.
No, Your Honor, thank you.
All right, and then 4, I think that's way overly broad, and we're not going to let you to go into that. So go ahead and prepare a order on this, Mr. Hamada. Make sure on the beginning of the order it says on April 12th as opposed to on this date, so I can tie it back to this. Try to get Mr. Lemoyne to agree to the form of the order if you can, and then go ahead and submit it. Email it to my court coordinator and to go ahead and e-file it.
Okay, thank you, Your Honor.
Thank you, guys. You guys be safe, okay?
All right, bye-bye.
Bye-bye. Okay, let me pull up the next hearing. Okay. So I believe our next hearing is Midland Funding versus Jan Bonga. Is that right?
Yes, Your Honor.
Okay. Tony, let's go on the record on cause number DC 202320, Midland Funding versus Jan Bonga. Counsel, make your appearances.
My name is Brian Staley. I'm appearing on behalf of Plaintiff Midland.
Bob Clark on behalf of Jan Bonga. Judge, I think I made a faux pas because I didn't know Mr. Staley was on this case. So I called Tim Elder. I've got him on speed dial, and now he's here to also. So they're double teaming me, Judge. But I was trying to make sure that Mr. Elder wasn't unaware of this hearing, because I think he is usually the man that goes after me on all these Midland. No, I'm sorry, he's not Midland. Mr. Elder is no longer with Midland. I have gotten confused. May I tell while we're here, this is a simple motion, Judge?
Sure.
To switch mediators, because Courtney is about double expensive of what my client has and what the case is worth.
Sure. Who do you guys want to use? Who would be someone cheaper that you would prefer?
Right. Oh, who would it be?
Yeah.
Well, Charles Oliver's one of the least expensive. And I've got a certificate of conference that there was no opposition to this. I don't know if I talked to Mr. Staley or who I talked
to. Your Honor, Mr. Clark, you didn't talk to me. I think you talked to Mr. Elder.
Yeah, Your Honor, I have a case against this defendant with Mr. Clark. Mr. Clark called me and said, hey, Yan Banga case, would you be adverse to a motion to substitute mediators? I said, sure, but ours is in the 193rd.
Okay.
Well, then it was a confusion. So I don't know Mr. Staley's position on this.
I don't have any objection, Your Honor. That's fine. If he wants to use a different mediator, as long as it's not a relative of his, and the expenses are shared, then that's fine.
I don't have any relatives that are mediators.
So Charles Oliver, does that work for everybody?
And
Is Charles,
Mr.
I haven't
Elder-
seen him in quite some time. Is he still mediating?
Right, I
a
think
couple
parties
weeks ago.
ought to go and have the most expensive mediator they can find. But if I can be excused, I'll get out of everybody's hair.
All right, thank you,
Okay,
Mr.
yeah,
Elder.
because-
Sorry for the inconvenience.
Thank you,
Mr.
Your Honor.
Elder used to work for Midland. It's a little bit, he's done, I was telling him, he's done the scenic tour of all the debt collection firms. So,
Just until they figure out how bad I am at my job.
oh no, he beats me all the time.
All right.
Thank you, Your Honor.
let's-
I'll get out of everybody's way.
Thank you,
Yeah,
Mr.
Tim.
Elder. Good to see you.
Good to be seen, too.
Okay, so did we agree on Oliver, or is there someone else you wanted?
That would be fine with me, Judge, if that's who he wants.
I just printed the order out. Thanks, if you don't mind.
Brian, did you have my proposed order?
No, I haven't seen it. I just don't think it's caught up to the file, but as long as it's, the standard language.
It's just the
Standard. I'll
motion's
just go ahead and
granted.
substitute it. I'll just, it has a blank, which is why I had a hearing on this, so I wasn't sure who you wanted to use, so I included, I'll go ahead.
And then I
write
put
it.
the rest of the original mediation order remains in effect. So I just changes the name. And
All right, well, Mr. Clark, Mr. Staley, good to see you. You guys be safe, okay?
Thank you,
thank
Your
you.
Honor.
Thank you. Bye-bye.
Give me 1 second. Mr. Becker, Ms. Oker,
Good afternoon, Judge.
afternoon. There you go. There's a Mr. Laurie here on the line. Mr. Laurie, what are you here for? You're muted, sir. You're muted.
Can you hear me now?
Yeah, what are you here for?
First Mercury Insurance Company versus Needham Roofing Incorporated. I'm a little early, I think.
Okay, well, let me just take a look at it. We'll make sure we take care of everybody. All righty. Okay, so First Mercury. Yeah, you guys are not until 3:15.
Yeah, I'm a little early. I apologize.
No problem. All right, we'll get started. Did we want to take this off of YouTube? I remember that was an issue before.
I haven't had a problem since Judge Williams signed the TRO, so I'm fine keeping it on YouTube for the access now.
Okay. Let's go on the record, Tony, on cause number DC 203832, Poose versus Anderson Homes Dallas LLC. Council, make your appearances.
Dorotha, oh. I'm so used to being a plaintiff and going first.
Go ahead, Mr. Becker.
I think we're the plaintiffs. Scott J. Becker for the Payas's with the McCatherine firm.
Dorotha Oker for defendants John Larson and American Real Estate Investments.
All right, let's proceed, guys.
Okay, thank you, Your Honor. I'm here today. I filed a motion to withdraw or strike our deemed admissions. I'd like to get into a bit of a timeline of the case as far as whether or not these removing the deemed admissions would cause delay. I don't believe that it has anything to do with delay in this case. So just for some background, March 6th of 2020, the plaintiffs filed a lawsuit against 11 different defendants about problems they had with their $1.7 million home. 2 months later, on May 14th, the defendant non-sued, or the plaintiffs non-suited 3 defendants. 2 defendants, my clients, filed their answer June 22nd. A default judgment was granted against 2 other defendants July 14th, a month after that. The hearing on the default, the damages for the default judgment was in August, so a month after that. So August 6th, there was already an interlocutory judgment against 2 different defendants. Very shortly after that, on August 10th, 3 defendants had a motion to withdraw their attorney. So they had filed their answer, but they're now pro se. To this day, those defendants are still part of this lawsuit. That left 2 representative defendants, which are my clients. Your Honor signed the motion to withdraw, the order allowing the motion to withdraw September 13th. On November 30th, 5 months after my clients entered their appearance, when filed their answer, the defendant, different side of the V for me, Your Honor. The plaintiffs sent discovery in the form of requests for admissions and interrogatories that were due on December 30th, 2020. Trial had already been set in this court for February 9th. It was e-served. Those discovery requests were e-served. I've looked through. I don't think they were additionally emailed. So they kind of fell through. Additionally, I was sick. I had a severe vitamin D deficiency. So I was just not doing anything that month and didn't understand why. So they were due on November 30th. Less than 3 weeks later, the plaintiffs filed a summary judgment motion on the deemed admissions. That was January 19th of this year. Very shortly, I guess 2 weeks before trial was supposed to start. They only filed it against the 2 represented defendants, and it have so far, as far as I can tell, have not filed any sort of summary judgment motion against the 3 unrepresented defendants. And it is, in fact, only a partial summary judgment motion. There's no request for damages, and there's still additional defendants. Shortly after that, the plaintiffs filed a motion to continue the trial. So the delay in the trial date was actually from the plaintiffs requesting it, and we did not oppose it. It came up during the hearing on the 8th of February that we had not responded to the admissions. I said I would get them in quickly. Little did I know my dad was going to die that afternoon. Then we had the storm. So we did send the responses March 14th of 2021. That is a delay of about 3.5 months, which we do apologize for. But when it took over 5 months to send discovery, we don't believe 3.5 months to get the admissions was any undue delay or would cause prejudice in this case. Additionally, the good cause was I was ill, and then a series of weather events and my father dying precluded us from being able to answer. Additionally, the admissions that we would like to deny are merit preclusive admissions. For example, whether or not my individual client was a party to the contract. The contract very clearly shows who are the parties to the contract, and it is not my individual client. To have a technicality where he is suddenly deemed a party to a contract is merit preclusive and would essentially make my client a death penalty sanction for not getting admissions back within 3 weeks when it took over 5 months to send any discovery. So only to the extent that the admissions are merit preclusive are we requesting that they be allowed to allow us to enter our denial of them and continue with any necessary discovery that might be needed on those points. That is all I have to say. Does Your Honor have any other questions?
No. Mr. Becker?
Judge, I understand that Ms. Oker has gone through a great deal of difficulty for the past several months. And I do not want to revel in that. I'm not trying to take advantage of her, difficult times. Okay. I've been in those situations. I've presided over cases where lawyers have had those situations. So I understand where she's coming from just a human being point of view. Okay. And I'd like to think that I haven't lost my humanity just because we have our law license and we're practicing. However, as we sit here right now, when we're talking about that this wouldn't be a delay, we have disclosures that were submitted to these parties last May. So we're coming up on a year, and they have not been responded to. Now, those aren't the basis of our MSJ, and those aren't the basis of the motion to undeem admissions here today, but it gives you some context as to the delay that the parties are causing, having nothing to do with Ms. Oker. Okay. When we last came before you on this motion, I believe the motion to undeem the admissions was set on a Monday or a Tuesday. And later that same week, we were scheduled to have our motion for summary judgment heard. And rather than go forward on both of those, the court, after hearing much argument, said, why don't I wait to handle the overturned admissions or not, and combine that with the continuation and hear it on Friday. Between that time and Friday, counsel and I were able to speak. She had referenced the idea that rather than pursuing this ultra aggressive strategy, maybe we could talk, pick up a phone, try and negotiate, try and mediate, all of which my associate has been trying to do for the past year. Okay. And there was a sequence of events where Ms. Oker did respond to say, hey, send me a settlement demand and we'll think about it. And I think that's the onset of when the no good, terrible, very bad things started happening in Ms. Oker's world, where she just lost touch, maybe for valid reasons. Again, not criticizing that. Maybe her clients just didn't talk to her, don't know. But we've been trying to do that. We took advantage of that delay a few weeks ago and said, you know what, rather than go forward with the hearing, let's schedule a mediation. We did that. They picked a mediator. We went ahead and did it on Zoom. And for the first 3 hours of mediation, nobody on the other side showed up. The mediator has never seen anything happen like that before, where for half a day, there's no one. Now, to her credit, Ms. Oker did inform me that there was some kind of situation arising with her client, but she did that the day before the mediation was scheduled. So it was just a little difficult to process that. We thought we would take advantage of at least putting our position forward to the mediator, which we did. And then still for 3 hours, there's nobody. It was a one-person tennis match. So when you're being told that this isn't for delay, that's inconsistent with the history of this case. I'm not casting aspersions on Ms. Oker. She has tried very hard to communicate with us, but I'm frankly a little surprised she's here, because during previous communications, she expressed to us the potential that she might have a conflict. I'm assuming she's resolved that to whatever extent, because she's going forward here today. But Judge, we're going to ask.
She may have had a conflict with this date, or may have had a conflict regarding the case.
Regarding the case and with the representation of various clients, not with this date of the hearing. Now, I'm going to respectfully ask the court to leave the admissions as is and proceed with this case, because it is only when we do things like this that anything gets done on this case. And we've been having to push this hill, up this hill in the summer against the grain the whole time. So we're going to ask the court not to undo the work that my associate has done by proceeding on getting the admissions submitted. And please, Your Honor, please do not allow this. I beg the court, do not allow this to be undone at this point. That would be a travesty at this time.
Response?
Yes, Your Honor. Respectfully, there are still 3 other defendants in this case who have not gotten any summary judgment motion against them. Respectfully, there's a judgment that we agreed to sever that they waited 4 months to sever, 4 months to sever, to start to collect, that my client will get a credit for. You can't triple dip because you've got 11 defendants that you started with. So when they cast a wide net, they need to actually try to catch the fish. At this point, it appears they found that somebody has an attorney and they're going after them. But this is not a case, okay, withdrawing the admissions would not end this case. It would not end this case. There is no request for damages. It's already a partial summary judgment motion. And there's 3 pro se solvent local defendants who have not at this point had anything filed against them. So we are not causing any delay. I'm sorry that they were unable to get our request, to agree to our request to move the mediation to the afternoon when our clients were available. I said, hey, there's emergency travel. He won't be here. Let's move it to the afternoon. They said, we'd rather show up in the morning. So the day after getting my second shot, I dragged myself out of bed and got there in the morning for exactly what they wanted to do. Apparently the mediator didn't even tell us what their offer was. So they had made an offer and we didn't even know what it was till afternoon. So I'm sorry that there's been this delay, but it's not us. I mean, I had some issues, but to act like your client would be able to collect because of this admission is incorrect, because they already have a judgment that I'm not sure what they're collecting on, that we agreed they could go start collecting. We did not attempt to stop the severing. We want them to go collect against some defendants. Having these admissions, which are factually incorrect, my client, John Larson, is obviously not a party to the contract. The contract says who the parties to the contract are. To have to say, no, we've decided to be aggressive by denying and defying reality is not being aggressive. That's not making our courts an area where we decide truth. That's playing games. And then, like I said, there's still 3 other defendants when this is done who haven't had anything aggressive against them. So I believe that we've met all the factors of good cause. I'm sorry I was sick and had the other things done. The second I was able to, we gave the denial. The denials are all things that are obvious denials. I mean, you can look at the contract and tell he's not a party. We're not doing this for delay. And we're not keeping this case from being disposed of because this is not anything that's going to cause it to be disposed of. It'd still be an interlocutory order and it'd still be a partial motion for summary judgment. Their motion for summary judgment doesn't even have an affidavit from their client. So they can still go back and get an affidavit from their client and file another motion for summary judgment. They just want one that's not based on reality. So I respectfully request that we are allowed to withdraw only those admissions that are merit preclusive and which we've attempted to deny with our admittedly late response. Thank you.
Judge, Your Honor.
Sure.
The behavior of any of the other defendants has no bearing on this hearing. Our client or our tactical decision to prosecute whichever portion of the case we want to prosecute has no bearing on this case. And oh, by the way, there are summary judgments pending for every defendant still in this case. So if that somehow matters to the court, and it shouldn't, everybody is being pursued. And to say that this isn't for delay when it defies reality based on the way that this client has engaged with us throughout this entire process. So again, Judge, there is no compelling reason for this court to undeem these admissions. Everything says.
I'm looking kind of at O'Connor's here and just looking at there's quite a few cases on motions to strike deemed admissions, a lot more where they were set aside than when they're not set aside. But some examples of cases when the requests were not answered because of some confusion caused by the party serving the request. City of Houston v. Reiner, R-I-N-E-R.
That wasn't the case either.
when the party shows diligence in attempting to resolve the problem as soon as it was discovered, In re Kellogg Brown and Root Inc. In the example, attorney immediately prepared and delivered responses after she realized she never received requests and could not find them in her office. Esparza v. Diaz, where it says defendant filed answers 6 months before trial, plaintiff was not injured, trial was not delayed. Employers Insurance of Wausau versus Hilton, the Dallas Court of Appeals case. Attorney drafted answers immediately after receiving requests for admissions, but they were not typed and served. Attorney filed motion to set aside deemed answers as soon as he discovered the problem. And then there's a couple cases where they didn't. I mean, it's a fairly, my impression of just looking at the Court of Appeals and that, and also in my other issues or other times where I've dealt with this issue, is a fairly low standard. This is obviously, I understand Mr. Becker's frustration in this, and that, you know, you went to the time to file this motion and get it heard. And, but, you know, the Court of Appeals, just like in the, when you're setting aside a default judgment in the Craddock factors, their standard is fairly low, that courts want to get to the merits of these things and not have it decided on a technicality, which I think is a good thing.
Your Honor.
And so I'm going to go ahead and allow the admissions, the non-merit preclusive admissions, to be undeemed. Anything else, guys?
I have one
Sorry,
question.
did you mean the merit
Sure.
preclusive ones to be undeemed?
Yeah, yes, that's what I meant.
So before we finalize here, Judge, I just want to make one last gasp in that every single case Your Honor read from O'Connor's, none of those fact patterns come anywhere close to matching what we have here. And so I understand the court's hesitancy to grant what is a rather severe remedy to my client, but I believe this is the set of circumstances where it is justified. And if the court is still not convinced, then what I would like is, if you're going to go forward with this, can we get some designation of the numbers of what the court is deeming to be? I mean, because as I understand it, the court is not.
That's fair, Miss Oker. What numbers are those?
I think that's fair as well, Your Honor. Let me see. Let me show you that we have denied, when it comes to the individual, John Larson, we have denied 1, 3, 4, 5, 6, 9, 11, 12, 13, 14,
How many did we say?
16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41. Number 42 is admit that you took advantage of the plaintiffs. So yes, we're denying 42.
Well, maybe the list of ones that you're going to admit is shorter.
Well, look, I mean, these are things like admit you entered into a contract. I mean, he's the individual. He didn't enter into a contract with them. I mean, these are all admitting you knowingly misrepresented something. Well, these are legal conclusions.
Judge, I point this out.
Why don't we do this? I'm going to put you guys into a breakout room. I have some other hearings I need to take care of. You guys consult on if there's one that you feel, Mr. Becker, that you don't think is merit preclusive, then we can talk about it. But why don't you guys discuss this, and then we'll just come back in when you're done.
Before you put us in the breakout room, Judge, there is also an MSJ pending against one of the other defendants that's not here right now.
pending as that I need to rule on?
Anderson Holmes, Ronnie Anderson, and Donnie Anderson.
And we've had a hearing and I just haven't signed it yet.
We had the hearing.
We had the hearing. I'll tell you what, we'll get back to you on that after we get out of the breakout room, but I wanted to make sure that was not unaddressed before we sign off entirely from the court today.
Okay.
All right.
Okay, let's get to the next hearing. You guys should have invitations there. Do we have anyone here on First Mercury Insurance versus Needham Roofing Incorporated?
Good afternoon, Judge. This is Morgan Madsen, present for the plaintiff, First Mercury.
This is Robert Laurie and Stephen Fields, present for Needham Roofing Incorporated.
All right, sounds good. Tony, let's go on the record on cause number DC 1917681, First Mercury Insurance Company versus Needham Roofing Incorporated. Counsel, make your appearances.
Hi, Judge. Good afternoon. This is Morgan Madsen for the plaintiff, First Mercury Insurance Company.
Your Honor, this is Attorney Robert Laurie and Attorney Stephen Fields for the defendant, Needham Roofing Incorporated.
All right, let's go proceed.
Judge, we're here on a motion to compel a single request for production response. Does the court have the motion to compel in front of it, or would it be permissible for me to do a screen share?
I think I have the right one, but you can go ahead and screen share it.
Okay, I don't know if I have to see if I can get that permission. Let's see. All right. Okay, hopefully, can everybody see a blue chart here on a PDF document I pulled up?
You can. Go ahead.
Mr. Laurie and Mr. Fields, can you see that as well?
Yes.
Okay. Judge, I figured the easiest way to distill the basis for this request for production is to reference the court to this blue chart here that's on page 2 of our motion to compel. And so by way of background, Judge, this is a insurance premium dispute. And my client provided commercial general liability insurance coverage to the defendant over a number of years. And by way of history, for example, and it goes back even beyond 2014, but I thought this would be a good screen capture of the parties' relationship. What the policy provides is it allows for an initial deposit premium, which is based on projected sales. And so the defendant, in connection with its broker, fills out an application for insurance and provides an estimate to my client of what its projected sales will be. And the reason that number is important is because based on those sales, my client can then gauge what risk it's undertaking. So when it issues a general liability policy, if there aren't many sales, then it's likely that there are going to be fewer or maybe no claims. If the sales, in contrast, are stratospheric, then the defendant is doing a lot of business, which means my client's exposure is necessarily increased. And so what this policy allows for, as it's written, is nobody knows what the end of the year sales are going to be, obviously. And so you take a reasonable good faith estimate at the beginning. The policy is then priced accordingly with a deposit premium. And then there's an audit at the end of the policy year. What you might refer to as a true up. And this was nothing new. It was established. If the court requires, we can go through the policy language that I've attached, which lays this all out. It's not a surprise. I don't think the defendant is claiming that it was surprised by this. And so, for example, for the policy year 2014 to 2015, the projected sales by the defendant, not my client, but the defendant, were $7 million. At the end of the policy year, an audit was conducted, and it was $11 million. So what that meant was that of the $87,900 that was paid at the beginning of the policy term, there was additional premium due of $113,000. And that was paid, Judge. And then 2015, 2016, again, the projected sales were 7 million. The actual sales were 16 million. The initial policy premium that was paid was 87.9, but there was additional premium due of 178, and that was paid. Then we come to 2016, 2017, and this is what the parties in this litigation, Judge, have referred to as the 04 policy. It's not written in 2004, it's just an 04 because those are the last 2 digits of the policy number. And we had, again, this $7 million projected sales, but the actual revenue, the sales by audit were 29 million. And so it skyrocketed, which meant that instead of the initial deposit premium being the 90,000, it ended up being 243,000. And so that's what my client filed suit over, Judge, is this premium of 243,000 being due. Importantly, Your Honor, other than a general denial, which I understand that's all they're required to do, but other than a general denial, there really isn't a basis so far that I can tell, and I'm new to the case, but there isn't an articulated basis for why that 243 isn't due. Instead, the fight coming from the defendant is over this 2017-2018 policy right here, Judge, where the defendant projected 9.2 million in sales and paid an additional premium of 110,000. So, Judge, this is the 05 policy. What has happened is the insured, the defendant, has refused to allow my client to conduct an audit, despite the fact that the policy clearly provides for it. And I've attached as an exhibit, and if the court would like, I can go through it, but I've attached the exhibits, which are the policy language, which says the insured is required contractually to allow my client to review its records. And this is what they did for these 3 years. I guess we know why they won't allow us. And it's because you can see here, Judge, whether you want to ascribe, ulterior motives or not, there is a demonstrated pattern of underrepresenting the sales. We go from 7 to 11, 7 to 16, 7 to 29. And so I suspect the reason they don't want to allow my client to do an audit is because there's this pattern of underrepresenting the sales. And so the premium, we don't know, but it may be extraordinarily high. But I'm not required to prove some kind of malintent on their part. This is discovery. I'm entitled to seek information that's relevant, that can lead to the discovery of admissible evidence, and they contractually agreed to the audit. And so I'm really perplexed. I tried several times to confer on this motion, and that's attached to my motion to compel, Your Honor. And by the way, here's the specific request. I tried to narrowly tailor it. This is the information my client would need in order to conduct an audit. I know the court knows the rules on discovery.
Let me go ahead and hear the response.
Yes, Your Honor.
Judge, this is Mr. Loring. Hey, Stephen, could you put up the minimum premium earned endorsement out of the policy?
Robert, I've got it right here if just for ease of.
If you got it, you hadn't read it, counsel, but we're going to talk about it.
Gosh, I'm sorry I don't know why that comment was necessary, but it's right up here. I've got it here for you.
Well, it's pretty clear to me, so I'm not understanding why we're here today. But Judge, let me tell you this. On the 04 policy, which is maybe the 4th year of this relationship, they did an audit, and during that audit, they canceled the 05 policy. The 05 policy, which he's talking about, which he didn't have this information as charged, they canceled the 05 policy about 3.5 months into a 16-month policy. And based on, because of this liability policy, they'd pay a deposit premium, the minimum deposit premium. For 05, that was $110,000. And to go back to 04, we've disputed the amount of the 243, and we haven't gotten all the proper offsets and everything. But 05, they canceled the policy, then charged him this $243,000, didn't give him any offsets, didn't return any unearned premium for the 05 policy, then sued him. And if you look at the minimum earned premium, well, first, if you look at their motion says you can do an audit under the language of the policy, but you got to go through a full policy year. And then according to his chart, you look at the total sales, and they're entitled to do that. And then if they had increased risk, it doesn't matter whether there's any claims, there's just increased risk, they can charge more premium. But the minimum earned premium endorsement on the policy, it's an endorsement, so it changes the policy. Well, first, the cancellation clause in the policy says if they cancel the policy, they got to return the premium pro rata. They canceled the policy on a renewal. And under section 551 let me get the right section. 551.052 of the Texas Insurance Code, they're prohibited from canceling a renewal general liability policy. So they violated the insurance code. But they went ahead and canceled it anyway, and they said underwriting reasons, because he'd already paid his minimum deposit. And that's a violation of the codes, because if they're going to cancel, they got to be specific. And that's another section 551.
Let's stay focused on this motion though. So they're asking for an audit. The contract provides for an audit.
It does not provide for it.
Okay, it does not provide.
No, if you look at the minimum earned premium, they only can do an audit over the minimum earned premium. But if you look down there, it says cancellation minimum earned premium. It says 3. If we cancel the policy for any reason, that's First Mercury, other than for non-payment of premium, and so there wasn't any non-payment, the minimum earned premium shall not apply. We will return to you the pro rata amount of the unearned premium.
So let me clarify what I was saying then, Mr. Loria. It wasn't precise enough. So if they had not canceled this, they would have been entitled to an audit, correct?
If it had gone through a whole year and there's a whole year of performance, but when they cancel, they're not entitled to an audit, period.
Okay, let me just I want to make sure I'm understanding this first, which is if they had not canceled this policy, then they would have been entitled to an audit. Your position is because they canceled the policy mid-year, that means they no longer, they had to, let's see, the minimum earned premium shall not apply, and they would return the premium to you, pro rata amount of the unearned premium. And so your position is because there would not be any need for an audit because they had to return the premium anyway, right? Is that essentially your position?
Yes, that the policy precludes them from doing an audit since they canceled it for reasons other than non-payment. The premium deposit for the 05 years was $110,400. The amount they owe pro rata back for after about 3 months of a 16-month policy is $91,304.78, which they have not paid. They've also have not pled that they're entitled to like any audit for 05, which I don't think they are under the policy language. So we've told Mr. Mattson that because of the cancellation, he wasn't entitled to this discovery, but he proceeded with his motion nonetheless.
All right, response to that?
Yes, Judge. That's exactly why I circled all of these provisions in my motion. You know, if someone wants to, lodge, say things like, I haven't read something, they better make sure their words taste good when they, because it clearly, it's Mr. Loray that hasn't read this, not me. There's a distinction here. If you look at sub 3, if we cancel the policy for any reason other than for non-payment of premium, by the way, Judge, the reason it was canceled was because of the repeated shenanigans by the defendant in underestimating their sales.
I object to that. There's no evidence of that, and that's not in their cancellation.
Well, it's no different than you claiming that there's a this is not trial. You know, you wanting to cite that there's some violation of an insurance code that doesn't even apply to a motion to compel a hearing is no more nefarious.
Guys, let's stay focused here. So get through with your argument.
Yes, Judge. So look, right here, unearned premium. So that's what they're glossing over, is we will return to you the pro rata of the unearned premium, which is a distinction from the term deposit premium right here. And so the whole basis is you can't figure out what the unearned premium is until you conduct an audit. That's the only way you can figure out. If there's a pro rata amount to be determined, it's based on, okay, here was a deposit premium. Now here were your sales. Now here's what should have been paid. Now we calculate that on a pro rata basis. That's how you have to do it. And there's no other way to determine what the unearned premium is other than by saying, okay, let's see what your actual sales were. Let's now apply that to what the deposit premium was. And then now let's reduce it to a pro rata basis. That's how you determine what's earned versus unearned. If there was a provision that is unearned, then they get a credit for it. But that's what I'm trying to figure out. And I've offered to enter into a confidentiality agreement. I've offered to enter into whatever provisional language would be necessary in order to protect Mr. Loray's client's financial information, you know. But that's the only way you can determine it.
Judge, point of clarification, right above that, it says the minimum earned premium, which is defined above and allowing them the audit, shall not apply if they cancel. It doesn't apply. The audit doesn't apply. Unearned premium has to refer to the amount of the deposit premium that hasn't been earned. To try to construe it any other way is, I don't read it any other way, but even if it is confusing under standard interpretation of insurance contracts, it's construed against them. Because even if we have a reasonable explanation, they even have a more reasonable explanation, its tie still goes, or it still goes to the insured, and that's standard.
I mean, I think he makes a good point here, which is it says if we cancel the policy for any reason other than the non-payment of premiums, the minimum earned premium shall not apply. The minimum earned premium is what's defined above, I guess, as.
That's where the audit
where
comes
is that
in.
defined? Where is that?
Audits minimum earned premium. That's what they audit.
The minimum earned premium.
Right.
We show it to the pro rata amount of the unearned premium. But what is an unearned premium? How do you define what the unearned premium is? What they paid so far? Or is that the premium deposit?
Yes.
No, well, first of all, there are different terms. As you can see here, there's the deposit premium and the unearned premium. And with regard to Mr. Loray's assertion that ambiguity goes against the drafter, maybe at trial, certainly not in discovery. But in any event, when if I may go, the audit here isn't paragraph C isn't restricted to unearned versus earned. It isn't restricted to deposit versus non-deposit.
Okay, so but what I'm most concerned about, if you go down to the previous page.
Yes, Judge.
Is where it says, if we cancel the policy for any reason, the minimum earned premium shall not apply. And then the audit applies to the minimum earned premium. With regards to audits, the deposit premium is stated in the policy. The declarations cannot be reduced due to an audit. Premium adjustments affected as a result of premium audits may be done when the policy is in effect or after the policy is no longer in effect. The due date for the audit premiums is the date show. So all the audit premiums, which is what this is regarding, deals with the minimum earned premium, as I read this at least. So I don't know how you would get an audit if the minimum earned premium no longer applies. Because the audit regards the minimum earned premium.
Because the policy language is discussing the unearned premium. This doesn't say that if we cancel for any reason, we aren't entitled to an audit. And nor does the language up here limit the audit to a minimum earned versus an unearned premium. There's no exclusionary language. This right here, this is auditing the minimum earned premium, but you can't determine what the unearned premium is unless you figure out what the sales were. And then you figure out on a pro rata basis, okay, if the sales were $40 million, and then you reduce that to a pro rata basis, and then you figure out what it is. And I'm just puzzled why the resistance of auditing such a small, I'm talking about a year's worth of records. I actually asked for a couple more years because you never know how they classify it, but I tried to draw it pretty narrowly. And so that.
So maybe I misunderstood. I thought you were just requesting an audit for the whatever 3 months before the cancellation. That was what the audit was for, correct?
No, we need to know what the total sales for the year would be, and then reduce that to you reduce it to a pro rata basis, which would then be
okay. You're right. You look at the whole year, then you do the pro rata basis.
Yeah,
yes.
That makes no sense, Your Honor. They canceled the policy. And this is an endorsement. If at the top of the endorsement, it usually has language, says, the following additional policy conditions supersedes any other policy conditions, and the name sure agrees that the total policy premium, et cetera. So the endorsement language controls over everything else, and the minimum earned premium doesn't apply. And you're not entitled to an audit. It makes no sense. They only do an audit after a year long. They canceled the policy. And then the minimum earned premium is in addition to the initial deposit premium. But the policy says, no, if you cancel for any other reason on payment, you got to return what's been paid pro rata. And that's what makes sense. And
I agree. It's not 100% clear what this means, but I think just looking at its totality, I've got to kind of parse all of this. I think that what I think this means is that the minimum earned premium no longer applies, which is what it says here. The audit comes from the calculation of the minimum earned premium, and therefore there would not be the need for an audit because it no longer applies. That's my reasoning on it. I hope I'm right, but I'm going to go ahead and deny the motion to compel. So is there an order on this that's been submitted, Mr. Laurie?
I don't think so, not yet, Judge. I'll draft one up and send it to other counsel.
So when you do that, if you could include today's date on it, so at the beginning where it says on this day, put on April 12th, 2021, and then try to get a sign off as the form from the other side. And once you do that, go ahead and try to do that as soon as you can. Go ahead and email my court coordinator as well as e-filing it.
Yes, Your Honor.
All right, guys.
All right, thank you. May we be excused?
You may. You guys be safe, okay?
Thank you, Judge.
Thank you. All right. Mr. Oker, Ms. Becker, are you back? I don't see Ms. Becker.
Judge, I think you might have to ask her to come back. We just figured out we're supposed to pop back into this room. So, and she may be waiting in the breakout room, waiting for you to pull her back or something.
All right. She could have left on her own, but I just didn't send her back here. I think there she is. Okay.
We only figured it out like 30 seconds ago. So
that's all right.
Hey, here we are.
Hey, everybody. Did you guys work it all out?
Sadly, Judge, we did not.
No.
But I do have a couple of things to help you wrap this up today.
Okay.
First, as I mentioned before we left to the other room, there are other defendants besides those represented by Ms. Oker whose motions for summary judgment are currently noticed up for today. And you can go ahead and address those before we leave today. Nobody
Okay.
has responded to any of the motions. Nobody has done anything on those to undeem anything, to respond to anything. So those motions for summary judgment are ripe for your granting at this time.
Okay, let me look those up.
And they got nothing to do with Ms. Oker.
It's good. Let me just look at
My
that.
favorite kind of MSJ.
Yeah. All right, let me. When were those orders submitted?
January.
And it's all in one order. I can resubmit it.
My associate's telling me he submitted one order as to each of the, like all of the defendants are in one order. That would include, by the way, Ms. Oker, so you would need to at least strike them.
So do this. Go ahead and submit a new order for me then that just details the orders, those that I'm granting. Go ahead and again include today's date on the order and email my court coordinator and e-file that as well. Okay.
I heard you tell the previous crew, make sure you put today's date, not
Right.
On this day, because you want to be able to link it back to the
Yeah, it
transcript.
makes it a lot easier in this era of COVID with everything being remote, and yeah, it'd make it a lot easier. So
Nice little breadcrumb.
yep, exactly. Used to be we could do document notes, but we can't do that on this system. So, all right. And then what do we need to work out with these different numbers?
I
With
think
respect to the admissions that she's asking you to undeem, what I'd ask is if she could submit to you an order that lists those numbers, because as we were going through them, we're unable to agree or disagree about whether or not all of them are in fact merit preclusive or not. And so if we could get a draft order, that would be very helpful.
respectfully, Your Honor, can I send a draft order to them and we can spend a little bit more time looking at these, because I think there's close to 50 of them, and we admitted some of them, and see, and then get you.
Yeah, why don't you do this? Why don't you go through them? I think she has a good point. See what you can agree to. Go ahead and agree as to at least, I know you don't agree that I should do this at all, but at least some of them are pretty clearly merit preclusive. And so as to those, go ahead and rule on those. Go ahead and mark those like agreed. And then for those you can agree to, then I'll rule on those. If it turns out that you just can't agree to anything, I'm going to have another hearing on this. But I would highly recommend that you try to agree to as much as you can. All right, guys.
That'll
Thank you,
work.
Your Honor.
I just want to bring this up while we're here and then we can shut it down.
Okay.
We still have disclosures that haven't been produced. We are not here on a motion to compel. I get it.
But when, Ms. Oker, when are you going to provide answers to those?
My assistant typed them up quite a while ago, so if we haven't, it's an error, and I will have that done by 5 o'clock today.
Same thing with the production and other requests that we put out there. So
I don't.
she's telling me she's going to get it to us.
We got a request for production. We just got interrogatories and RFAs.
We've sent multiple emails. This is part of that ongoing back and forth where we're trying to push the sled up the hill in the summer. If you need them sent to you again, we'll send them again.
Yes, please, because what we have been going back and forth with is the interrogatories and the RFAs, and that was all we got. So if you
We'll
have
send you the
RFPs,
email that sent the email the first time. So, and Judge, the last clarification I will make is that your rulings today is that Ms. Oker has 2 clients before you, Mr. Larson, and I confused the company name, so give me a second.
American Real Estate Investment.
American Real Estate Investments, or AREI. And she's only making these arguments as to Mr. Larson. I don't understand your ruling to apply, and she's not urging any of the arguments as to AREI. I haven't seen anything in those responses that addresses that entity. It's all with the individual.
respectfully, most of the denials are from the individual because it was kind of a carbon copy of the company. So it was, is the contract between the company and the person? Well, yeah. Is it between the individual and the person? Well, no. So to the extent that there's denials from AREI, I would say that it's that, but the main concern at this point is the individual, because we believe those to be far more merit preclusive than what was for AREI.
So the draft order we're going to get is going to apply to him, and that's it.
I filed it for both. I requested it for both. The examples I used were for the individual. To the extent that there's merit preclusive for AREI that were not admitted, vast majority I believe were admitted, then I'm requesting it for them. It's just, it has more highly impacted the individual, so I used him for an example.
Okay. Does that answer your question?
Not really.
Okay.
That sounded, you know what, Judge, I apologize because I feel like I sounded rather glib to you, and I never want to disrespect the court in my tone of voice, and I think I did there, so I apologize for that. But we're right where we started before this hearing, is that it's a morass of confusion, and which one they're answering, which one they're undeeming, which defendant is she arguing for, which defendant is she not?
I believe I stated my appearance at the beginning of the hearing, Your Honor, and named the clients that I'm representing. And I believe my motion also names the client that we were representing. And we made the argument in my motion that we believed all of the admissions that we are denying to be merit preclusive. I'm sorry if there's confusion, but I don't believe it to be coming from me, Your Honor.
What does it say in the motion? Does it say us to both?
Yes, Your Honor.
Mr. Becker, does it say us to both?
I don't have their motion in front of me, Judge. I can't open that screen up and run this Zoom session.
Okay, yeah, just whatever it says in the motion is what I'm granting.
Thank you, Your Honor.
Thank you, guys. You guys be safe, okay?
You too, Your
Thank
Honor.
you.
Okay.
All right, I think we have one left. Mr. Cantu. Are you there, Mr. Cantu?
Yes, Your Honor. Hello.
Hi, I saw your motion for new trial. I'm concerned I don't have any problem with the what you're requesting. It's just I don't think I have plenary jurisdiction over this. It was this, you filed the motion for new trial more than 30 days after the dismissal. So I'm not sure how I have plenary power.
Well, under Rule 306A5, Your Honor, gives me a maximum of 30 days after the last day to discover that the judgment had been rendered, which we meet that deadline. And Rule 306A5 actually doesn't have a deadline, but the courts have put in place a 30-day from the ultimate discovery of judgment deadline. And really what we're trying to do is just change the designation of the file closed as a DWOP to a straight file closure. Because as of August, all the documents required by the clerk were on file with the court. What happened was we filed the case in August. We got a notice of DWOP at the same time we had sent our proof of mailing in. So I explained to staff that in less than a week, they should have all the documents required to finish the filing. And I called back 2 weeks later to confirm that they had gotten it, and it was uploaded into the system. So if you look at the docket of the court, the actual filing to domesticate the foreign judgment and then the proof of mailing were all received in August and September of last year. So when I confirmed that they had received the paperwork, the clerk said, no problem, it'll be recorded. And that way you can, your judgment will be domesticated and the file will be closed. So I discovered that a DWOP had been granted when I was going in to request a writ or an abstract be prepared by the clerk. And at the same day is the day I filed a motion to extend post-judgment deadlines and the motion for the new trial. But ultimately, I'm just trying to get a nunc-pro-tunc on the filing closure status from DWOP to a straight closure, because they told me that was the court's procedure for a domesticated judgment.
Okay, let's kind of parse through this. So can you see the screen okay, Mr. Cantu?
Yes, sir.
So you filed the original petition on August 6th. And then the dismissal for want of prosecution notice was on, let's see. We filed the notice of dismissal on August 11th. So we sent you notice on August 11th. And that notice said that, sorry. Let's see. We set hearing for 11:30. Okay. And then on 11:30, we filed we granted the DWAP. I guess you didn't show, I guess, for the dismissal docket. And then you didn't file a motion for new trial until March 16th. So I guess you said a lot of stuff there. I'm not exactly clear. You have 30 days. It's always been my understanding of the law, and I've dealt with this quite extensively, that you have 30 days from the dismissal, date of dismissal, to file a motion for new trial. If the motion for new trial wasn't filed until March 16th. So I guess if there's a way I can do it, I don't have a problem with it. I just still don't think I have plenary jurisdiction. So explain again how I have plenary jurisdiction to do this.
It's all in Rule 306. A4 tells us to extend post-judgment deadlines. We have X number of days to discover it. And the 30th day, it must be discovered within the 90th day post-judgment. And from that date, you have a total of 30 days more. So really, they just need to be specific, say 120 days to file your motion to extend.
What 306, what at 306 of the Texas Rules of Civil Procedure?
Yes, sir. 306A4 says you can
I'm
file the
looking
motion.
at 306 is recitation of judgment. Oh, 306A4, I get it, okay. So what is your argument here, that you didn't get notice of the judgment? Is that the issue?
Yeah, we never have. And if you check the docket, it was never mailed out either.
Can you go grab Rhonda for me? So I don't know if we can get Rose or you to look at this. So he says that this notice, the notice of dismissal wasn't sent out on that date or was never sent out. Can you, where do I find that? Over here, okay. Let me see. Okay, where do I find that?
Okay, so it doesn't look like anything was said. Do I have a note up there?
No, so it's on 806. This is the issue is when was proof of mailing petition?
We're waiting for Oscar. I think he's on the phone with other judges.
Okay.
Wait.
Here.
Oh, it was returned. Go click on that. Is that one there? That's not something I'm saying.
No, that's something we would send out.
Did you hit the right one? No, I hit some tiny.
is the correspondence? No, it's something else.
Usually I have it.
Uh,
We'll just we'll probably be long because it's the attorney.
Yeah, but this is what was sent on August 11th. So I get, okay, let me go back here. Should be on 11:30 is when we dismissed it. 8/6. Because the DWAP was on 11:30. I don't like how they do this. It's hard to follow. Okay, that's this. It wasn't dismissed on 8/6, so I don't get this. Is that it?
I don't recognize that. I don't.
Can you, I don't understand
I
this.
was-
Okay, so
Let me
let's,
research a little bit and
can you get,
Rose.
yeah, get Rose.
Okay, what you think?